You said in this op-ed that pregnancy resource centers are nothing but faux clinics, that's your word, that pose as real medical facilities. Do you remember writing this?
I don't remember that particular article, Senator, but I take your word for it.
You don't, it was 2018, you don't remember writing it?
Just not that particular article, but I'm happy to answer whatever questions you may have about it.
Well, let me just ask what you meant by faux clinics. Do you stand by that pregnancy resource centers are faux clinics that pose as medical facilities? Faux means fake, of course. So, Mr. Rickelman, can I start with you? In 2018, the day after the Supreme Court ruled that California couldn't force pro-life pregnancy centers, resource centers, to advertise on behalf of abortion clinics, you wrote an interesting op-ed in the Huffington Post. I have it right here. You said in this op-ed that pregnancy resource centers are nothing but faux clinics, that's your word, that pose as real medical facilities. Do you remember writing this?
I don't remember that particular article, Senator, but I take your word for it.
You don't, it was 2018, you don't remember writing it?
Just not that particular article, but I'm happy to answer whatever questions you may have about it.
Well, let me just ask what you meant by faux clinics. Do you stand by that pregnancy resource centers are faux clinics that pose as medical facilities? Faux means fake, of course, so you're saying that they're fake clinics?
Senator, I believe the case that you're referring to is the NIFLA versus Becerra case, and I was involved in that case as an advocate on behalf of amici, and the case concerned a California law that was a consumer protection law that was enacted after some women reported that they felt misled about the types of services that were available at the centers, and that's all that I was referring to there.
Well, no, I'm asking about your comments that pregnancy resource centers are faux clinics. We have had representatives from pregnancy resource centers here before this committee testifying under oath who testified that at their centers they employ trained, licensed medical professionals. So is your testimony here that these folks are lying under oath, that that's not the case, that these centers are all fake?
Absolutely not, Senator. Again, I was just referring to the amicus brief that I'd written as an advocate in that case, which shared stories of women from California who had gone to some pregnancy centers without understanding that they didn't provide any medical services at that particular center.
Well, how about this? Is an ultrasound a legitimate medical procedure in your view?
Of course, Senator.
Okay. So countless pregnancy resource centers provide ultrasounds. Those are medical procedures. Ultrasounds allow fetal abnormalities to be diagnosed and treated early on. So surely those aren't faux clinics. In another article, you said that these clinics cause women to suffer concrete harms to their health. That's just confusing to me. I mean, these clinics, and there are thousands of them across the country, including in my home state of Missouri, provide free pregnancy tests, free ultrasounds, free prenatal care, free adoption care, free diapers, free clothes, free car seats. Many of them even provide free job training. And yet you're saying that they're faux clinics.
Senator, I absolutely support all parents having the resources they need. In that article, I was merely speaking as an advocate about the particular law that had just been evaluated by the Supreme Court, which was a consumer protection law in response to some women who had felt misled by some centers.
You were using the Supreme Court's decision as an opportunity to tarnish and to go after pregnancy resource centers, which is frankly something we've seen from our friends here on the left who would like to eliminate these pregnancy resource centers and shut them down all across the country. They're very open about that. I'm just trying to figure out, is that your view too? Would you like to see these pregnancy resource centers that provide this free medical care to women shut down across the country so that free medical care for women is no longer available?
Senator, once again, I was just speaking about one particular law in California that was enacted as a consumer protection law just to make sure that all women could have whatever information they needed to make the best decisions for themselves. That's all that I was speaking about.
Let me ask you about the Supreme Court's decision in the 2007 case, Gonzalez versus Carhart. You're familiar with that case, I assume?
Yes, I know that case.
Let me just read briefly from the case. Dr. Haskell went in with forceps and grabbed the baby's legs and pulled them down into the birth canal. Then he delivered the baby's body and arms, everything but the head. Then the doctor stuck the scissors into the back of his head and the baby's arms jerked out. The doctor opened up the scissors, stuck a high-powered suction tube into the opening and sucked the baby's brains out. That's partial birth abortion. Congress banned this procedure by bipartisan majority in 2003. Do you think Congress made the right call there?
Senator, what I know is that the Supreme Court upheld that act, I believe about 15 years ago, and it's been settled law in the country for all of that time. And of course, I will faithfully follow it if I were so fortunate as to become a judge.
Well, I'm asking because in 2019, news outlet in Oklahoma quoted you saying you oppose any attempt to regulate abortion procedures. The article says that you opposed an Oklahoma state law that, quote, bans dismemberment abortions. And it quotes a public statement you released saying we cannot overstate the harm this decision will have on women in Oklahoma. Politicians should never take medical options off the table for pregnant patients. So you're against bans on partial birth abortion.
No, Senator. The law has been settled there for 15 years. And just to be clear, all of the work that I did as an advocate was within the confines of Supreme Court precedent, which allowed states to impose limits on abortion, but also recognized that women should be able to make their own personal medical decisions.
Well, my time has expired. I know there are other senators who want to ask questions, so I will return the floor to the chairman. I just want to say in conclusion, Ms. Rickleman, that I have to say that your characterization of pregnancy centers, your opposition to, frankly, radical pro-abortion laws, I think are very, very troubling. And it gives me grave concern about your nomination. Thank you, Mr. Chairman.
Senator Hirono.
Thank you, Mr. Chairman. We have two judicial nominees.
In the final minutes of the hearing, the air seemed to tighten as Senator Josh Hawley leaned forward, holding up the printed page like a piece of evidence pulled from a crime scene. "I have it right here," he declared, his voice sharp, deliberate, unmistakably theatrical. And with that gesture, that sheet of paper raised like a challenge, the tone of the exchange shifted from routine vetting to something more confrontational, more revealing. His target, judicial nominee Ms. Eckelman, sat composed but visibly navigating the tension as he pressed her on her past writings, her advocacy, her words about pregnancy resource centers and abortion laws. What unfolded was a collision of two worldviews. Hawley, uncompromising and accusatory, spoke as though unearthing a hidden truth. Eckelman, calm but measured, answered as an advocate-turned-nominee trying to reconcile personal history with judicial restraint. The senator read her past articles aloud, phrases like faux clinics, accusations of concrete harms, earlier opposition to abortion restrictions, each word framed as a window into her judgment, her values, her future on the bench. And she, in turn, reminded the committee again and again she had been speaking as an advocate within precedent, within the law, in the context of specific cases, specific clients, specific facts. But the exchange was about more than the words printed in Hawley's hand. It was about power, who wields it, who interprets it, who gets to decide how past advocacy informs future impartiality. It was about the tension at the heart of every judicial nomination, the struggle to distinguish belief from duty, work from worldview, opinion from obligation. And under the glare of the hearing lights, that struggle played out with cinematic clarity. When Hawley asked whether pregnancy resource centers were fake clinics, whether her critique meant accusing medical professionals of lying under oath, he wasn't merely interrogating a footnote in her resume. He was challenging her moral credibility. He was questioning whether a judge who once criticized certain centers could now rule fairly when those issues came before her. She responded with nuance, that some women had reported being misled, that the legislation at issue was a consumer protection matter, that her article reflected advocacy grounded in stories, not condemnation of all centers. But nuance is fragile in a room built for confrontation. Then came the second shift. Hawley, reading in graphic detail from Gonzalez versus Carhart, the language of the partial birth abortion procedure, the kind of excerpt designed not to uncover legal reasoning, but to provoke an emotional reckoning. The senator framed it as a test of principle. Did Congress make the right call? Would she endorse bans on the procedure? Did she oppose all abortion regulations, as a past statement seemed to suggest? Eckelman repeated the line that nominees often cling to like a lifeline. The law is settled, the court has ruled, and she will follow precedent. But Hawley wasn't satisfied. For him, this was not simply about precedent. It was about trust, because beneath every pointed question was an unspoken one. What kind of judge will you be when no one is watching? Will you interpret the law faithfully, or will ideology seep into the seams of your rulings? Will you uphold the boundaries of judicial restraint, or reinterpret them to fit your own history? This is the core of America's judicial confirmation drama. The fear that beneath the robe lies not impartiality, but politics. And in that room, in those tense minutes, that fear was on full display. Hawley ended his remarks with a solemn warning. Her writings were very, very troubling. They gave him grave concern. And that is where the deeper meaning of this hearing emerges. Because this wasn't just a senator questioning a nominee. This was a reflection of a country locked in a fierce battle over who controls the narrative of morality, medicine, and law. Pregnancy centers and abortion procedures, these are not merely abstractions. They represent the front lines of America's cultural fracture, where questions of life, autonomy, faith, and government collide with relentless force. The hearing became a microcosm of that collision, a nominee defending context and nuance, and a senator defending conviction and clarity. It exposed the broader truth that in our political system, hearings are never just about qualifications. They are about defining the moral identity of the country. One nominee, one precedent, one exchange at a time. They are about forcing the nation to confront what justice looks like and who gets to interpret it. As the chairman called on the next senator, the confrontation faded, but the implications lingered. This hearing, like so many before it, reminded us that the judiciary is not insulated from the storms of American politics. It is shaped by them. And every question, every answer, every raised document is part of that shaping. In the end, what happened here was not just a clash between a senator and a nominee. It was a moment that asked each of us, what do we expect from the people entrusted with our laws? How do we measure integrity? Who do we trust to interpret justice in a nation where even the meaning of justice is contested? These hearings matter because they reveal not only the character of nominees, but the priorities of those who question them. And, ultimately, the values of the nation watching from beyond the committee room. If you believe in keeping these moments visible, in examining power with clarity and conscience, in understanding not just what happens in Congress, but what it means, subscribe to the Congress Brief. Support the work that brings these truths to light. Because democracy depends not on silence, but on witnesses.